Stormy Daniels' attorney back in the headlines again with another headline-making move in his case against the president. But he's asking a federal court to move the case a little bit faster. And former federal prosecutors we spoke with say that is not likely to happen.
He looked very taken.
Tonight, Stormy Daniels' attorney seeking to be the first to depose this president of the United States. The White House again forced to respond.
Look, the president has denied the allegations. We've spoken about this issue extensively, and I don't have anything else to add beyond that. Anything beyond that, I would refer you to the outside counsel.
Daniels' attorney, Michael Avenatti, has filed a motion seeking to depose Donald Trump for no greater than 2 hours. Among the questions, what Trump knew about the $130,000 his lawyer, Michael Cohen, says he paid in hush money to keep Daniels quiet about their alleged affair. Avenatti claims in the motion that a sitting president is not afforded special protection from a civil suit regarding conduct before he or she entered office. He cites the case Clinton v. Jones, the 1997 Supreme Court ruling that compelled President Clinton to give testimony in a sexual harassment case filed by Paula Jones. That case has already been cited by a judge in New York as justification to allow a defamation lawsuit by another Trump accuser to go forward. Daniels' motion also seeks documents directed to Mr. Trump and Michael Cohen, Trump's attorney, on various topics relating to the hush agreement.
We raised this motion with the other side.
Avenatti also claims he had a March 21st meeting with Mr. Trump's attorney, Charles Harder, and asked whether Trump was part of the original non-disclosure agreement with Daniels, the document that is missing Trump's signature.
And we heard crickets. They don't know. He said they don't know yet whether Mr. Trump was a party to this agreement. How do you not know whether you're a party to an agreement unless you're just trying to make it up as you go along?
Harder has not responded to CNN's request for comment.
Avenatti makes no sense whatsoever.
David Schwartz, Cohen's representative, fired back this morning in a statement to CNN, calling the motion to depose the president ludicrous and a reckless use of the legal system in order to continue to inflate Michael Avenatti's deflated ego and keep himself relevant. Schwartz says the motion is unusual because it asks the judge to allow early discovery in the case before Trump's attorney has substantively responded to the allegations. All this, as Avenatti now suggests in an interview with Wolf, more women have come forward since Daniels' alleged affair was revealed.
I can announce that the number's not 6, it's now 8.
He says 2 of those women have also signed confidentiality agreements.
They filed a motion to depose the president of the United States. Is that going to happen?
It's certainly not going to happen right away. Michael Avenatti, he's very aggressive, very media savvy, but I think he's jumping the gun a little bit here. The first thing that's going to happen, and the most important part of this case, is that the defendants, the representatives of Michael Cohen and the president, are going to try to get this case moved to arbitration and out of court. That's going to be the first thing that the judge is going to want to resolve. If the Stormy Daniels succeeds in keeping it in federal court, then there is a possibility that there will be discovery. But I think the judges want to proceed step by step. And the first step is going to be to go to, decide whether to go to arbitration, which is something the Daniels team really wants to avoid because it's more or less a secret proceeding.
Yeah, they want it public. Jeff, a lot of questions that presumably they would like to ask the president that he might have a hard time answering. Specifically, one question: did you know about the $130,000 payment to Stormy Daniels as part of this hush agreement?
Of all the questions hanging out there, and there are many, this is a central one here because it goes to a potential violation of campaign finance laws and other things. But the White House was asked about this again today at the press briefing. Sarah Sanders would not answer it. They have not answered it. So we don't know the answer if he actually knew about it. But we do know the president's relationship with Michael Cohen. We know that their offices were virtually side by side in Trump Tower at the time. And Michael Cohen, over the course of his time as the president's top aide in many respects, has done very little without the approval of the president. So I think it strains credulity to think that the president would not have heard about that at the time.
Yeah, it certainly does. You don't want to. We know the president did not sign that hush agreement, even though there was a line there. It was blank. There you see it right there. DD, that was the pseudonym for the president. Why can't the White House give us a straight answer when they're asked why he didn't sign it and all these other related questions?
Look, Wolf, this is clearly a story the White House doesn't want to be anywhere near, that the president doesn't want to address publicly at this point, despite the fact of what he may be thinking about it privately or how he might feel about it. They're very content to refer this to outside counsel to say that this has been litigated in the past, that the president denies the claims. But what I think has been really interesting here is this is a president that we've seen and who's been described by people as a counterpuncher. We've seen him time and time again when people attack him, he punches back and he hits back really hard. He hasn't done that with Stormy Daniels. And in fact, the people that represent him, White House Press Secretary Sarah Sanders among them, she hasn't gone on the record to pick apart piece by piece the things that Stormy Daniels said. There's just been kind of this nothing to see here approach that I find, frankly, quite interesting.
Michael Avenatti, the attorney for Stormy Daniels, the adult film star who says she had an affair with President Trump, has filed a motion in federal court seeking to depose both the president and his attorney, Michael Cohen, to ask both of them about the $130,000 payment that Cohen made to Ms. Daniels just before the 2016 election, seeking to ensure her silence about the alleged affair. And once again, White House Press Secretary Sarah Sanders fielded another question about it at today's briefing.
You haven't answered the substantive question about whether the president was aware of the $130,000 payment that was made under an agreement in which he is explicitly named to keep Stormy Daniels silent. Can you answer that question? You were asked 3 weeks ago today and said you weren't aware. Are you aware now?
Look, the president has denied the allegations. We've spoken about this issue extensively, and I don't have anything else to add beyond that. Anything beyond that, I would refer you to the outside counsel.
I'm joined now by Stormy Daniels' attorney, Michael Avenatti. Thanks for being with us. What is the Michael Cohen's people want this to be an arbitration. They don't want this in open court.
Correct.
And that's what they said the contract calls for. They've tried to move it to federal court, which has a history of pushing things more into arbitration. How is that affecting what you're doing today in terms of pushing to be able to depose the president, to be able to depose Michael Cohen?
So what we filed just after midnight this morning, Anderson, was a preemptive motion. And what we've asked for is a number of things. We've asked for a 2-hour deposition of the president, a 2-hour deposition of Michael Cohen, some limited document requests where we can ask for specific documents to be produced, and then we want an expedited trial date on the issue as to whether an agreement was actually entered into. Now, why is that important? Because before their motion to compel arbitration can be heard, a fundamental question must be answered. And that question is whether there was an agreement to begin with.
Right.
Whether the parties actually reached a meeting of the minds and had an agreement. Without that agreement, you never get to the motion to compel arbitration. And that's under what's called the Federal Arbitration Act. So we've had this motion in the can for a while. We were expecting them to remove to federal court. They did. And we've now filed this motion, and we're highly confident that the court's going to grant it.
So if the president's not a signatory to the actual contract that was signed by Michael Cohen for the LLC and Stormy Daniels, why try to depose the president? What are the questions you want to put to him?
Well, I mean, we want to find out what the president knew, when he knew it, and what he did about it, if anything.
You're not talking about are you talking about the actual allegations of an affair, or did he know that Michael Cohen was doing this? Did he ask Michael Cohen to do this? Is this, essentially an in-kind campaign contribution? Or was the president involved in some way?
We're focused on the formation of the agreement and the terms of that agreement and what the president knew and when he knew it. We're not interested in what the White House spokesperson or deputy spokesperson has to say. We want to put the president under oath, and we're going to ask him some very simple questions. Normally, you're permitted 7 hours under the federal rules. We've only requested 2 of him and Mr. Cohen. It's one thing, Anderson, to lie to the press. It's another thing to potentially perjure yourself under oath. So we're going to ask those questions. We're highly confident in the motion.
Why are you say you're confident in the motion? What is there precedent for this? I mean, is this is an accelerated schedule you're asking for?
Well, this is not just some crazy notion that we thought up overnight. I mean, we've been looking at this for a number of weeks. We've been prepared for this. We've done our homework. There's extensive precedent in the Ninth Circuit The president may not like the Ninth Circuit Court of Appeal.
He's spoken a lot about the Ninth Circuit.
Yes, I happen to love the Ninth Circuit Court of Appeal. It's the circuit in which I practice quite a bit. I think the judges are very learned and able, to say the least. And there's extensive precedent within the Ninth Circuit for the granting of this motion. It's really almost black letter law, what we're asking for. And I don't think, quite honestly, the president's team thought through this process of removing the case to federal court. They certainly did not see this coming.
Do you know how quickly you'll get a ruling on this?
Well, we've asked for a hearing on April 30th, and we're going to be before Judge Otero. I have some experience before Judge Otero. You know, he's a very smart, no-nonsense federal judge. And when I say no nonsense, I mean no nonsense. And I'm confident that he's going to hear the motion on April 30th, and he's going to issue a decision shortly thereafter. And if the motion is granted, Anderson, I can envision us taking the deposition of Michael Cohen and the president within 30 or 45 days of the end of April.
Michael Avenatti, we'll see. Thanks very much. Appreciate it.